Most people think a will is enough to protect their family, but here's the truth. Even with a will, your family still can end up in court spending months, sometimes years, waiting for things to be settled. I'm Steven Lundberg, an estate planning attorney here in Cary, North Carolina. If you ever wondered whether a will or a trust is right for you, I'm going to break it down simply so you can protect what matters most. The problem with wills: probate, delays, and privacy. A will is a great starting point. It says who gets what, names guardians for your minor children, but a will doesn't avoid probate. That's the legal process where the court verifies your will, oversees distributions, and there are fees along the way. In North Carolina, probate can take anywhere from 6 to 12 months for a straightforward probate administration, and court costs and attorney's fees can easily reach $5,000 to $15,000. Everything is also public. Anyone can look up what you own and who received it. If your family needs access to funds quickly, they can't get it until the probate is generally finished. That often is the hardest part for loved ones. A trust works differently. Think of it like a private container that holds your assets, your home, your bank accounts, your investments. While you're alive, you're still in full control. But when you pass away, there is no court process. The person you named as successor trustee can immediately manage and distribute everything in accordance with your wishes, privately, and often within just a few weeks. Another big benefit: a trust can plan for incapacity. If you become unable to make decisions, say you're in the hospital, or you develop dementia, your successor trustee can step in seamlessly and avoid the need for a court-appointed guardianship. That peace of mind alone is why most of my clients choose a trust once they understand the difference. A will usually costs less upfront, but it will lead to thousands of dollars in probate costs later. A trust does cost more to set up, but it saves your family far more time, stress, and court fees. I like to say you can either pay a little now, or you can pay a lot more later. Let's look at two quick examples. Scenario 1, a will only. Sarah has a will, leaving her assets to her 2 kids. When she passes, her estate goes through a probate for 10 months. The court and legal costs cost around $12,000 before her kids ever see a penny. Scenario 2, a trust. David and Maria set up a living trust. After they pass, their trustee transfers their assets to their beneficiary within weeks with no court involvement. Their kids never deal with probate. Everything stays private. Now, with a trust administration, generally there will be some legal costs and fees to transfer or help the trustee in transferring those assets to the beneficiary, but those costs are generally much less than having to go through a full probate. Over the years, I have helped hundreds of families avoid unnecessary court battles, stress, and delays just by setting up a plan that works for them. I've also seen what happens when families don't plan ahead, and it's heartbreaking. Estate planning isn't about wealth, it's about love. It's about making life easier for the people you care about most. If you're unsure about whether you need a will, a trust, or something else, let's talk. I offer a short, no-pressure consultation to help you understand your options. Click the first link below to pick a time that works for you, and we'll walk through what makes sense for your situation. You'll leave knowing exactly what you need and what you don't. Again, just click the link below, and I look forward to helping you protect your family and protect your future. I'm Steven Lundberg, an estate planning attorney in Cary, North Carolina, helping families plan with peace of mind today, tomorrow, and for generations to come.